Good afternoon and good morning to the people out there. This is Mark Stignani, and I'm joined by Jaci Sprtel. And welcome to the presentation. I think Jacqueline, do you want to introduce yourself?
Sure, thanks, Mark. My name is Jaci Sprtel, and I am a patent analytics specialist at Black Hills IP. So today I'm going to be kind of coming at it from maybe a slightly different viewpoint than what Mark will bring, but I kind of come at it from how do we take data and analytics and help do some patent valuations from a data perspective.
Yeah, and as you can see here, I'm analytics chair here at Schwegman. Formerly, both Jacqueline and I did work for Thomson Reuters, so to my friends in the information services business listening in, hello, thank you for joining us. I've spent a good portion of my IP career doing analytics, and also been very, very privileged to sit in the presence of great minds in the form of NLP people and other R&D scientists that have helped me understand limitations of analytics as we go forward here. So let's move right along into, and one final disclaimer for my clients on the line here. Nothing about this has anything to do with any of you or any work that I've done with you, and these are all my own opinions. So there's my disclaimer. All right, come on. There we go. Whoops. Too much. Okay.
So today we'll be talking a little bit about 4 parts in our presentation. The first is, what are some of the problems or challenges with algorithmic-based valuations of patents? And then what are algorithms or analytics, not so good at, and what are they good at? And then lastly, we'll round it out with a suggested approach to evaluating using analytics and algorithms. I want to go to the next one. So what are some of the challenges with patents? First off, they have a lot of intrinsic value. So, you see the text, you see the claims, see the images, what kind of value? One person might value it at something else. Another person might go, oh, this is too narrow, and, we don't see a lot of value in it at all. Also, a lot of the times patents can be really kind of cumbersome. Reading one alone, we've seen one where, there's hundreds of pages of specification, and you're trying to comb through it for that one little nugget to determine whether or not it's a valuable patent for you. And then if you times that, time by, a couple hundred patents, you could be spending months, think of it for litigation, reading through patents to find the information and to really give it some type of value. Also, patent claims can be very broad, and while from a prosecution standpoint, that's great, but when you're trying to value something, how do you know if, yes, you have a broad claim set, and maybe that's valuable when you're purchasing, but maybe when you go to litigate, that broad might be attacked in litigation. And then patents also require tending. Things you only have a certain amount of time, and then they have to go into the public domain. So you want to be able to use them and get the value out of it before they expire.
And one thing I want to leave with the viewers' memories here is the word images. Now we're going to come back to that a little bit later, talking about how analytics deals with images in patents. So just want to call that out. Another problem with patents is that one patent to one target is a very different approach than the same patent to another target. What's not valuable, what's valuable. It's very, very hard to tell what one patent is universally around. I mean, for those looking at patents, like, for instance, Amazon's patents coming up for expiration here, assessing what's valuable is really a very subjective process. Design around, and many times is available depending on how someone puts something together. And also a lot of what they have patented, a lot of times just isn't plain old detectable by the casual observer. You have to actually get into somebody's product and tear it apart before you can kind of find those bits and pieces. And then finally.
Yeah, so another challenge with patents is the cost. For anyone who's, tried to prosecute a patent and maintain a patent, you know what I'm talking about, and Mark and I have done plenty of that. And, some key points here, the bad patents cost just as much as the good patents. So the ones where you spent hundreds of thousands of dollars potentially, protecting it in several different countries, and then suddenly that product line is no longer valuable, that costs just as much as, another line of products that took off and you never thought it was going to go anywhere. But it does seem one common thread is everyone seems to not let go of what we call bad patents, or patents where there's no longer any use to the company. They think at some point, you put it out in the trash can and someone's going to pick it up and say, yep, we found value in it, and they're going to make that $1 million product off that idea and run with it. So everyone wants to keep going. And when they do that, what they start realizing is it's going to get into this called twilight zone. The cost to maintain are going to go up. You have to pay to renew it or to keep prosecution going on it. And then since those costs are going up, you have to balance your overall budget, and you say, well, maybe we don't do as many new filings, and maybe that one little idea that R&D person had doesn't get a patent filing on it because you didn't have anything in your budget. And all that comes around when we talk about money is, why do we have to pay for human analysis when there's so many algorithms out there? And so that's where we'll start talking a little bit more how algorithms come into play.
Yeah. So, just a rough set of categories here about the types of algorithms that different systems use to identify value or statistical value, I should say, in various sets of patents. We have clustering where either there's an automated clustering that you're based upon keywords that you're harmonizing on. You could be categorization, either using an agreed upon category system like the CPC or the IPC or the U.S. patent classification. Algorithms are very good at comparing and cross-referencing one matter against the other, especially where you've got a bunch of fielded data. They're pretty good at sorting things, how many words, sort this by how many words are in the independent claim, or how many things are in the independent claim that are unique words. They're fairly good at, and once they've been trained, and we'll talk more about training later, about suggestions. You can actually have software algorithms that sort and suggest with a high degree of precision and recall things that you want to understand. They're also very good at statistically presenting things that are fielded data in a bunch of patent classes, and predominantly that. So we'll talk a little bit about those. And Jackie, you had something on data collection?
I did. And so what Mark just listed are, some more sophisticated algorithms and what they do for evaluating. In my business, a lot of what I use algorithms or kind of analytics for is to get initially that data collection. So for example, I've done several things where we do data validation. So a customer has a set of data. We then go out and grab it publicly. So we use algorithms to kind of grab that collection of data and do some basic analysis on there. So sometimes I use, the algorithms on a very, baseline sense, and then that can play into the other things Mark just mentioned.
Great. So let's start with algorithms. Not just do poorly, but they actually are terrible at. Algorithms don't provide a real valuation of patent. And I really want to stress this. Anybody who gives you a patent strength or a patent score or something, it's just an amalgamation of statistical evidence that may or may not, might be useful, may not be useful. So almost everything on this list is subjective, with some of the stuff at the end being a little more objective. But patents algorithms don't tell you how much a particular target might pay for a patent. It does not tell you subjectively how broad a claim is. There are algorithms out there to judge whether the claim is broad or not, but it can't tell you if it's broad and it's fits the product you're trying to address evidence of use on. It's not going to tell you whether they win litigation or whether someone will go forward and license a patent. And it won't. And that's the thing is that the patent valuation is still a very, very subjective art form rather than a science at this point. And so we use a lot of the statistical and clustering algorithms to help us start at the most important things statistically, and to help us, find something that wins us faster than having to sort through the whole bucket. Jacqueline, you had some other things here?
Yeah, so kind of the bottom two, and again, Mark was kind of coming at it from a patent valuation standpoint, and I am almost kind of the beginning stages of, before you can evaluate a patent, you want to kind of make sure your data's there. So again, this whole comparing data in fields, if you don't have the right filing date, which may again go off of some other deadlines, that definitely can affect the valuation of a patent. Also things too, when you're divesting and you try to figure out the valuation, if you have some, assignment and knowing, the current patent owner, again, the algorithm can help you get there a little bit, but they're not always be able to tell you those nuances of if there's a chain of title that's really messy, can the algorithm properly determine that this is the current owner?
And that's a constant problem, especially when you have a lot of acquisition going and a lot of merger of portfolios. Sometimes there's, or not sometimes, most times there's always an error in assignment chains that needs to go back and be repaired before you go into litigation. So,
yeah, I've never had a clean data set.
Yeah. So one of the ways that algorithms are mostly set up here is they use training algorithms. You basically use subject matter experts, humans in general, that provide what we call a gold data set. And they go through and they sort documents, and then you sit there and you put your algorithm on top of that, and your algorithm learns statistically how that goes forward, how that should be selected, how that should be sorted. Watson, I'm going to bring up a little later because I had a number of people asking me about Watson and patent analytics, and we'll cover that a bit more later. But algorithms are really much better when they're trained in, especially in the topics that you're looking in. So the problem with patent valuation is nobody has done a good training set of patents and how much they're worth. And you can go harvest statistical, but very few people tell you how much they actually paid for a patent. And there's very few sources of good statistical evidence of what a particular patent is worth and why it was paid for. So just different ways that you can do training here in the matter. Jump on Watson for a few seconds here. This is just a full chart of Watson. The part I wanted to bring everybody's attention to, that there's a small little button down there called trained models. So Watson, of many things it is not, it's a very good savant-like algorithm that can, whip through things that it's been trained on, and it runs through all the different variations, all different various sets. And as long as the model is good, the results come up and better in a higher format and training. Example how a poorly trained Watson model looks here. There's a URL out there that allows you to put images into Watson and see what Watson thinks they are. Here's one where Watson can't tell the difference between a barn owl. They think it's an animal. They have high confidence it might be a cow, and slightly less confidence it's a bird. So this is kind of the current state of the art when it comes to image recognition. And remember, images are a full third of your review process in the patents as well, just to make sure you're in the right ballpark. Another thing that happens when you don't train it, I just stuck a patent drawing of a fairly easily recognizable product into Watson and saw what came out there. And the Watson tool came out with, we think it's a study, and you definitely know it's gray. And then they have the audacity to ask, did we wow you at the end of that? So as you can see, not quite ready for prime time in this whole area of things. So this is just, as an example, where the perceived peak of analytics is right now is not very far. So,
but Mark, you could just keep feeding those patents into Watson, and then it would be great. We'll replace all of us, right?
Exactly. No, I think, I'm not worried about that for a very, very long time. And, for the listeners here, I am coming at this from a law firm perspective. So I certainly am looking at these things as far as risk and risk mitigation purposes as well. So now let's move on to what algorithms do well. Jacqueline, did you want to do that?
Yeah.
Mine? Okay.
Nope, that's absolutely mine. So there are definitely things that algorithms do well, and here we touched upon them earlier, but clustering words, finding patterns, claims versus, other claims, similarity, even citation impact. That one actually, I really enjoyed the citation impact, figuring out whether or not it came from an examiner, an IDS, how many citations that particular patent has, had cited to it. Those are all great. And overall portfolio statistics, I use that a lot when, people are trying to figure out from a competitor standpoint, how many do they have? What countries do they file in? What's their filing trends look like over the years? Even being able to categorize a product, so using a combination of these, finding patterns. So they're, finding a categorizing and then figuring out the statistics for those. But really for me, what I think algorithms do well, and happens with me a lot, is data comparisons. So Mark was mentioning he comes at it from a law firm perspective, but I come at it more from customers coming to us. They have projects a lot that, if they're in-house counsel, they have time to maybe do some in-house prosecution and manage portfolios, not necessarily do projects of, is our data correct? And if their data is correct, then obviously the value to them goes up for several reasons. So they'll come to me and say, hey, we have some data. And it'll be my job to go out and verify whether or not that data is correct. I'll definitely use algorithms to go find me that data and do a comparison of, do I have the same filing date that my customer does? And if I do, that's a quick win for me to say, yep, I agree, it's correct. But where, my expertise comes into play is I get to say when it doesn't match, I'm the one making that final decision as what is the filing date. So you get the expertise of a human, but you get the algorithm to get you kind of 80% of the way.
Yeah, and there's lovely, a lot of these things come up with very lovely metrics. So you can look at, a number of things and give some relatively objective, performance comparison as you're doing, using algorithms as well to help you find things that might be of value. So let's see, oops. Did I do that? Okay, there we go. So what do we use algorithms for? I use them to get a starting point going. I look for kind of a speed dating view of the world. You can give me everything that looks like this patent semantically, or above this certain thresholds of similarity in a statistical evidence situation. After or before specific data, I've been looking for prior art or infringing behavior that's been cited, citation impact that's been cited more times by the examiners in our 3628 in regards to a 101 rejection or analysis rejection, have been litigated or challenged by an IPR. We also use it to gather in both data, and I think Jacqueline, that's more of your point there in that as well. But I mean, we use it for we use it to get started fast and not charge a lot to our clients. In the first deliverables that we put in front of them to establish the value proposition of what we do.
Yeah, and the last one I touched upon it earlier about this assignment and determining ownership is there's definitely a place for algorithms to go out and look at the assignment data and try to determine who they think owns it, because what it can do is it can narrow down the field. If we're assessing 7,000 patents for ownership, we can take a look and go, yeah, that reasonably looks like that should be the owner, and we can narrow it down and go, okay, this is the subset I really want to look into. I don't think the algorithm did it correctly. So it does definitely make the time more efficient and our product in the end more reliable.
Yeah. And so this is another thing doing, especially when we're doing M&A analysis for a client on a target. One of the things that we can do is look for, asset impairment, things where we're missing assignments. We might have trade secret issues where, former, high-profile inventors are working for the next employer who's a competitor. So we're able to give prosecution metrics on whether or not, a patent has had a lot of RCEs. We want to look at prosecution history estoppel for those, or how many office actions, how many restrictions is, if we're doing continuation mining of a patent portfolio and trying to increase the value, we can look at the number of restrictions, see if something else was left on the table during restriction practice. But yeah, I mean, the algorithms are very, very helpful in this, and all this relates into value. But each one is a single little facet that somebody has to cobble together. And Jacqueline, you had a
Yeah, I did, and I want to touch on a few more points that you had on that missing and incomplete assignments. I see this more often than not, that a customer will come to us and say, we know we filed all of these assignments for these 100, but go ahead and confirm that we did. And I'll come back and say, well, only 75 of them did. And they'd go, oh, no, I pointed to this. And they get confused on applicant versus assignee or assignor and the assignment. So if it's not filed through the assignment database, it's not recorded. So for example, if you filed the assignment with the application, it might be in pair, but it is not at the assignment branch. So it's not recorded and on notice. So that's kind of an education that I've had with several customers on that, and then they really recognize the additional value that kind of the subject matter expert can bring to that. On prosecution metrics, Mark, you pointed out a couple of examples, but I had another customer who did it when they were divesting. They wanted to make sure that when they divested a certain set of patents, that it had an equal set of patents from their standpoint for valuation. So, if they had 10 patents that had several RCEs, that they were splitting that properly between the two divesting companies on that. So that was a very interesting project, and was great to see kind of that metrics matrix. And the last one here for me, I know most people don't think about this for asset impairment, but again, if you don't have the basics down of your dates and your data, this can definitely affect your renewal due dates and your prosecution deadlines. And obviously, if you miss those and they go abandoned, you can pay more money to revive, or you end up abandoning something that could be of intrinsic value to you.
Yep. And the one other thing, as Jacqueline was talking about here, is that we also have the aspect of looking at the performance of various and sundry law firms as well. And we're able to judge which law firm has been doing a better job at certain classes of patents and so forth and so on. I mean, it's hard to say that it's an objective measurement, because each patent is different and hard to do. But we are able to, again, pull up and see, especially when you're looking at an asset purchase of a competitor or a target company, that how the law firms do their job, or did they do it well, is also something we can use algorithms to do in assessing the value of a portfolio. So ultimately, subject matter is necessary. It's ubiquitous, because patents say things in ambiguous or less than clear formats. So we don't draw really clear lines in the claim world. Being able to tell whether a patent covers tech X or tech Y requires subject matter expertise. All of these things that I've got up here, I'm not going to read them off, but it really has a great deal of subjectiveness and subject matter expertise required to answer these well and clearly. We always use subject matter expertise supported by machine technology, because we find that the machine does lots of things very, very well, like sorting, categorizing, checking for this and that and the other thing. Whereas someone who's actually got to read the important paragraphs of the patent and compare them with the important pictures and compare them with important claims is still very much a human process. And so we really caution, I really caution on simple statistical measurements of whether a patent is covering someone or not. Because it really comes down to the all elements rule on two fingers. Does this element is in claim equal the element that's in the product that I'm looking to assert a patent against? Jacqueline?
Yeah, all I would add to that is I always think about it that an algorithm is going to get us 80% of the way, and it's up to the subject matter expert to, get that extra 20%, because what that 20% brings is understanding and context to the situation. The algorithm or the analytics tools that you're using do not understand that you're using, I go back to my assignment stuff, that you're trying to divest, and overall understanding what you're trying to get at. And so therefore, how you take that data and how you deliver it could be different if it's in acquisition versus a divestiture versus data verification. So there always needs to be that human component, and definitely a subject matter expert is the way to go on it. And I think understanding really gets you the best quality product.
Absolutely. So we're going to give kind of our suggested approach to analytics-supported patent valuation. Surprise, surprise, it's different for each target product or company you're going for. So We like to use machine processes to identify prospects using mechanical, statistical, and semantic means. But then once we look at the target's evidence of use, that really starts to drop us into a human assist, because absent a direct compare and kind of a rare word extraction of a marketing brochure that directly matches up against claims there by machine, someone's got to read this stuff, and we have lots and lots of ways of bringing synonyms and claim fragments and things that are easily meaningful and clusterable to the using machines. But then at the end of the day, the subject matter expert, at least at the law firm, has to kind of bring things together and say, yeah, better or worse or not so much. Then once we have those high potential matters segmented out, we begin mapping those out. We have, we've developed our own technology that lets us speedily map, products and claims against specifications and non-patent subject matter. What helps us map against the product first, then map against the portfolio. Secondly, if there's a friendly assertion or a licensing thing to go into play. But once that's all done, once we tell you how big something is, how you can or can't design around it, whether you can detect it or not, this is when we want to suggest you hire someone who actually is in the accounting space and does evaluation as a general practice as well, because the professional evaluation of the matters that matter is both a legal and a fiscal activity. So, this is why we don't feel very good about saying one statistical analysis is going to tell you what your patent is worth, and I think that anyone that says so has a lot of talking to do, hand waving to do to prove it. And then we go back and we rinse and repeat for the next target. It one size fits one in our view of analytics supported patent evaluation. We just give you a better result than someone who just goes strictly to the fiscal expert, because we tell you which ones actually have the ability to be asserted. Jacqueline?
Yeah, and from my view of the world, a lot of the times I'm even one step removed, and that is I'm just there to provide as much objectivity to the situation as possible. So, for me, I may understand that a divestiture is happening or an acquisition is happening, therefore that's how I'm doing this assignment. But the outcome of that, I'm not tied to that. So I just produce the data and I explain it, and it is up to the company or the client to kind of interpret that the way they need to for their product. So my objective is to get a deliverable that they can act upon, and that they don't have to do anything else but take a look at that and make a decision, an informed decision. And so with, a certain level of expertise and understanding, you can get that to the customer in an efficient way, and then they can make their decision, because of course that's not their everyday job, is to evaluate patents. Normally people have several other things on their plate if they're still managing other portfolios or things of that nature. So, they want to be able to make a quick decision, but an informed decision. So from my standpoint of doing a lot of data verification and assignment work, that's really what I kind of value my job and the role that I think I play for my customers.
Great. And this is where we're at the close of our formal remarks here, and I want to open it up for questions here. But did have one come through as I was listening to Jacqueline close out here. We also do these things to look at kind of deadlines, patent term extensions, and terminal disclosures, disclaimers, excuse me, as well as we're bringing portfolios in for M&A work. Simply because a lot of times because it's so hard to keep things alive when you need to keep them alive and keep track of what additional days you have on something. We also use analytics to help pull out PTA and TDs in our pair data as well. So, and so with that, I'd like to open the floor for questions, suggestions. We have a good number of you out there. So if you have any questions, please let us know. Otherwise, I appreciate your time and patience in listening to us. Oops. Are there any Questions? I'm not able to see whether there's questions up or not. Chris, can you speak on them if you see them?
I can see it as well, Mark, and we don't have any at the moment. We must have explained it perfectly.
Yep, or, well, anyway, give us a couple more minutes. I think I did see one pop up here, I thought. Any comments about pharma patents and supplemental protection certificates filings? Yeah, well, at this point, that's not something we've actually gotten in, we've gone out and built analytics to pull out yet. So that's still pretty much a hand job to bring things for the supplemental protection certificate filings and that sort. So that has not been brought in. I'm actually not aware of anybody in the commercial side that has done any of that. But, if you'd like to follow up with me directly, I'm happy to, take that on a phone call. We can talk about it in specific. But in general, for pharma, we're not there. What does SME stand for? Subject matter expert. So that's somebody who knows what they're doing in the area of technology. Anybody else have questions? Okay. And, basically anybody who's interested in talking to us. Okay, another question here. One time we hear there's a ballpark number on what a patent is worth, 100K to 200K for mechanical and electrical. There is a couple different websites out there that regularly publish what they think the average value of a patent per sale is worth. And it runs between 100K and 200K. I think it's down significantly in the last 2 quarters. But they on a quarterly basis have published a number of statistics around what a patent is worth. So I believe that would be the basis for that opinion. I think the better way is a patent is worth exactly how much someone is willing to pay for it to either avoid a lawsuit or to step forward into a comfortable licensing situation. I have another viewer who's asking about any comments on demand letters. Nothing in the analytical space is yet there. If we have a demand letter, though, that we can take, if there's an identified patent and an identified product, we have a way of very, very quickly overlaying the demand and any claims made in that demand against the granted matter and the accused product. So, on about 30 minutes or 40 minutes notice, we can compare one matter to one demand letter, in a fairly fast format. Don't quote me on that time, but it's very fast. It's under a day in that respect. Jacqueline, anything you want to do? A follow-on question.
You're doing great, so I'm going to let you keep rolling.
Great. Follow-on question back on the evaluation of the patent. My guess is that's live data they put up there in the PowerPoint. I will actually share with you that source, and we can argue over whether that's a valid source or not.
Yeah, but Mark, from our opinions on, our previous roles, it's at least a nice ballpark. It by no means is the end-all be-all, but I think even from, our expertise, I'd say that ballpark between 1 to 2K, if you're going to go international on filings, is definitely a nice way to get some numbers around it.
Yeah, and it's also, it's certainly at least the cost of replacement if you have an international patent family as well. So I have another comment on using algorithms to help define white space in the technology. Here's the problem with white space. White space is a negative space. What is not claimed? So an algorithm that tries to figure out what's not claimed is, I've yet to find an algorithm that knows what nothing is. So that's, the whole, whenever someone uses white space, I have to ask them very clearly what they mean, because when I do white space analysis, I come together with an ontology of questions for the people who are looking at the white space and what they think they want to find. So if I can say, I want to go into the space of, fracking, and I want to know what the white space is in someone using this type of fracking slurry, this type of fracking material, and this type of a borehole in which direction it's going in. Then I can, make the ocean small enough to boil that we can do a white space analysis. Then we can ask questions tangibly for an algorithm to help me out on that. So that's the problem with algorithms in white space, is that if you don't define white space as what's missing, then it's not white space. So I don't think algorithms do a great job of it, unless they've been construed in such a way. I've asked to summarize the following. We cannot avoid the hard work of analyzing patents on a patent basis, but algorithms will assist us in reducing those numbers in which we would start the analysis. I think that's a fair way to do it. Analytics give us high potential starting points. Many times, and we've been very disappointed by high potential starting points, but at least it helps us start to talk about something. I mean, there's, citation impact shows us what the examiner is valued when you're doing, examiner citation impact. And so that's, in many ways, I think that humans who are assisted by analytics are much more precise and defendable than humans that don't do analytics and simply do subjective analysis. And then analytics by themselves do not do an adequate job of providing and understanding the value of an organization's IP.
And Mark, a lot of the times I'll use this example. So I think of Apple, right? I have several customers who will come and say, well, I want to know what Apple's doing. That's a very broad statement, right? So how do we narrow that down? And so, algorithms can help us saying, okay, by classification and categorizing that, we can say, okay, are you into hardware? Are you into software patents for Apple? And then we can narrow it down into the certain technology classes that might be important to them. And then we narrow that with the classifications and that it's Apple, and then we can start taking a look at things. Maybe we start looking at title and narrowing it down, so when we are going patent by patent to evaluate it, we're not wasting our client or our customer's time looking at 10,000 patents. Maybe we've narrowed it down to 1,000. So our role a lot of the time with Mark and myself is to provide the value to a small subset and not to a large amount. So using us to help narrow down that.
Yeah. And so what we're trying to do is be very efficient with our clients' money. I mean, at the end of the day, we're going to do, here's the best starting points. If nothing ends up panning out in the high potential ones, then we have a second tier that we can go back and start looking at. But the one thing that we're still waiting for is something like a Watson that can make that intuitive leap and say, something that doesn't exactly mean something, and I don't have the thesaurus to do it, and that we have a best guess that these two things are related. Analytics do a very good job of correlating one thing to one thing, but the subject matter expert is required to say that that's meaningful. I mean, there's lots of different statistical jokes out there about correlating two unrelated things there and having a high correlation of it, and sometimes it just is. So it doesn't look like there's any other questions coming in to my audience. And to Jacqueline, thank you so much for doing this with me. And I'm very happy to follow up and answer any other questions you have. The firm's website's SLWIP. I'm in there. I'm easy to find them on LinkedIn.
And Mark, two things. One, we should talk about what the next webinar is, but we got one last question very quickly. Is there a consensus that a patent that has many family members is more valuable than a more narrow scope of protection? Honestly, you're probably going to get, if you had 10 subject matter experts, you're going to get 12 opinions on this. I think it depends what your overall objective is. If you want a lot of protection, so if your idea or your customer's idea, you want it to be protected worldwide, then obviously having a lot of family members, if cost were no object there, having a lot of family members and filing in several countries is the way to go, and that's more valuable for them. But sometimes having a very narrow scope of protection on that, and they're very precise with their money and they know where they want to be, sometimes that can also be valued for that customer very highly because they got exactly what they wanted, and they swapped that out for protection in other countries. Mark, do you have any thoughts on that? Or
yeah, there's a consensus that the company that filed with many, many patent members believe it to be valuable. But one thing that I've found in analyzing many, many patent families is that unless you do your mapping of your claims as you're putting these things through the prosecution, there's a huge number of family members out there that virtually claim the same identical thing. I mean, the claim fragments are literally cut and pasted together, and there's one little nudge or one little nuance that's turned left or right. And so there's a lot of patents that have many, many family members that somebody spent $1 billion to protect worldwide that honestly, I don't think they're worth even the price of replacement on. So, I find that consensus is more informed by statistics than it is informed by actual real claim scope. I hope that answers your question. All right, and y'all see the next one there. Please join us. These are a lot of fun to do. And I think that, oh, we got one more here. Oh, it's just a thing.
We're very popular. Oh.
Yes. So again, if you have any questions, feel free to just give us a call at the firm or at Black Hills. Happy to answer any questions and clarify anything we've said. Appreciate your time.
Thank you.